Well, good evening, everyone, and welcome to the first in BritCourt's mini-series of webinars on litigating abuse of dominance. And tonight's session is going to focus on substantive developments of practical interest for litigation. The two presenters hardly need introducing, but I've got to do something, so I'm going to introduce them anyway. And they are very illustrious and will be known to you. Robert O'Donoghue, QC, is one of the leading competition law silks at the bar. He's appeared in major cases across the courts in the UK as well as the EU courts and in hearings before the UK and EU competition regulators. His recent cases include Fenatoin, Preventex and Royal Mail, Slovak Telecom and various ongoing CMA cases in the pharma sector. He's a full member of the Brussels Bar, so he retains rights of audience in the EU courts post-Brexit. And he's also the co-author of the Law and Economics of Article 102 TFEU, which, if I might say so, is the essential practitioner text on this subject and should be on all of your bookshelves. David Bailey has a glittering career at the Competition Junior Bar, where he's been standing counsel to the CMA since 2015, and he won the Competition Junior of the Year award in last year's Chambers Bar Awards. His recent cases are pretty much the same CMA cases as Robert's, but on the other side, and he's also acting for Qualcomm in the Consumers Association and Qualcomm case, as well as doing an Article 102 case for the Irish Competition Authority against Ticketmaster. David is not only the co-editor of the last edition of Bellamy and Child, but also the co-author of Wish and Bailey on Competition Law, the 10th edition of which is coming out this summer. So get your pre-order copies in now. He's a professor of competition law at King's College London, and he's called to the Irish bar. So like Robert, he continues to have rights of audience in the EU courts post-Brexit. So Robert is going to kick off introducing the series as a whole and then doing the first part of tonight's presentations.
Okay, well, thank you very much, Dame Kelyn, for your, first of all, your kind introduction, and second, for agreeing to chair the first session of this mini-series. Kelyn, of course, as many of you know, recently went to the bench, and we were sad, of course, to lose a colleague and friend from BritCourt Chambers, but the bar's loss is the bench's gain. And on tonight's subject matter, one of the many great attributes she brings to the bench is a profound knowledge of the subject matter that we're about to discuss. She really is one of a tiny handful of judges who could be classified as a real technical specialist in this difficult area. So that is very much to the good. As Dame Kelyn said, I wanted to, first of all, introduce the mini-series in a bit more detail. So this is the first of 5 sessions. And what we've tried to do is to do something maybe slightly different, to focus more on things which are of litigation or at least practical interest. And as you'll see from the different session topics, some are sector specific, some are essentially procedural, interim injunctions. So there's hopefully a bit of something in there for everyone. As you'll see from the illustrious list of chairs, unless you're a dame or a knight or a lord, your chances of chairing a session are next to zero. So we have a fantastic lineup. This is the first of 5. They're relatively short, less than an hour. And the format is to try and have a leading chairperson, at least one silk, at least one junior, and crucially to leave plenty of time for questions. So my plan is to speak for about 20 minutes, followed by David, and then we'll leave 15 or 20 minutes at the end for any and all questions. So what David and I wanted to do was to really focus on half a dozen points and to try and do those in a bit more detail. And as indicated, the focus in terms of the first session is to look at points of substance, recent developments that seem to us of practical interest when it comes to thinking about litigation. So starting with my first point, the next slide, please. So the first issue I've elliptically called the death of the pigeonhole. Now, what I mean by that is the following. Many of us know, and many of us will have participated for some years in the elaboration of different categories of abuse through the case law and decisional practice. And there's been a very careful process over many decades building up this body of case law. And, for example, if you take refusal to deal cases, there's the seminal Bronner case, there was refinements in IMS Health. So there's been quite a careful process over some decades of building up essentially legal conditions for particular forms or categories or types of abuse. So that is, to some extent, an important historic trend. Now, in my view, what we've seen in the last number of years is, to some extent, a shift away from the categorization or pigeonhole approach. Now, some of that is inevitable, of course, because once one moves away from legal form to economic effects, it is inevitable that formal categorization becomes either redundant or of less significance. So that's one factor. The second factor is one that David Bailey is going to pick up on in more detail, which is a very recent trend and a significant one in the case law, is to develop what is called object type abuses. And I mean, essentially, as David will outline, it's quite a straightforward analysis conceptually. Object equals purpose, and if the purpose is abusive, then they may well, subject to justification, be an abuse. So to some extent, that has also tended to detract away from the need for specific legal conditions and has shifted things more towards the focus on the purpose of conduct. So that's the second development. But the third development, which I want to focus on a bit more detail, it is undoubtedly the case, in my view, based on a number of recent cases, that the English courts and the EU courts have quite actively and deliberately, it seems, moved away from categorization approach and to adopt something which is less rigid and less formal. Now, the first example I think of this is a case which is relatively recent, but not that recent. It's the Purple Parking and Heathrow case. In their paragraph 79, Mr. Justice Mann said, Heathrow submissions require one to treat each of these examples in the essential facilities type of abuse as being individual pigeonholes into which one must fit a case. That is an erroneous approach. The statutory examples and the subsequent case law are ways in which the basic wrong can be committed, but at all times an eye must be kept on the basic wrong itself. Now, that was endorsed more recently in Streetbat by Mr. Justice Roth, so it has a very good pedigree at this stage. The second example is a case that David will focus on in a bit more detail, the Baltic Railway case. And there in 177, you see, in my view, a pretty clear example where the Commission says there's an abuse on the market, removing without objective justification the track in the legal and factual circumstances described below, thereby giving rise to potential anti-competitive effects. So this again seems to be gravitating towards a concept of abuse which is quite fact and context dependent, which is getting away from categorization, certainly on the historic case law. So that's maybe a second example. And a very recent example from the 25th of March is a case I was involved in, Slovak Telecom. And there you see a very strong push by the Court of Justice away from the conditions in the Bronner case law into something which, again, is more focused on the concept of identifying relevant anti-competitive effects in the economic and factual context. The court says, and I quote, the imposition of those conditions in Bronner was justified by the specific circumstances of that case, which consisted in a refusal by a dominant undertaking to give competitor access to infrastructure that had developed for the needs of its own business, to the exclusion of any other conduct. So it seems to be almost putting Bronner into a pigeonhole of one, which is the Bronner case itself. And to a good extent, that simply builds on a development which we already observed at the level of the Court of Justice in Telia-Sonera a few years ago, where the court said, in the context of a margin squeeze specifically, you don't also need to show that the Bronner conditions are satisfied. That was the beginning, I think, of a recent and clear trend away from formal categorization or pigeonholing. So that's the substantive developments. Now, moving on to the next slide, I mean, in terms of the implications, the practical implications of this for litigation, in my view, one can make a number of points. I mean, first of all, it does seem to me that what I would call the more freewheeling approach to abuses, decoupled from pigeonholes and categorization, that seems at first sight quite claimant friendly, because you don't have to nail your colours to any particular pigeonhole or mast. You can identify factual circumstances, economic circumstances, and say, well, this is a case in its own facts, and I've identified the relevant anti-competitive effects, and that is sufficient. So that's one point. Now, in the other direction, acting for defendants, in my view, one should always remind the court that where there is case law and there are conditions which seem bang on point, then as Mr. Justice Mann said at proper parking, where the case law contains a principle which says that in factual situations of type X, condition Y must always be fulfilled, even though it is not required in all of the cases. So we shouldn't throw the baby out with the bathwater. There are certain abuses, for example, predatory pricing, which is subject to specific conditions. And if I were acting for defendants, it's important to remind the court that these cannot be airbrushed in view of recent developments. Now, the more fluid approach in recent case law also raises interesting implications for strikeout and reverse summary judgment. And to some extent, they pull in different directions, because on the one hand, you may think if your case is indeed novel, it may not be straightforward to persuade a judge that it has significant merit. I mean, if you're reinventing the wheel or coming up with something entirely new, which is unmoored from the case law, that may lead to some puzzlement. Now, on the other hand, as the Court of Appeal noted in Intel and Via, a novel abuse, certainly in a developing area of law, may be a reason why strikeout or reverse summary judgment is inappropriate. One has to see how the case law develops. So the absence of categorization may pull in different directions. Now, ultimately, it seems to me that if your case is indeed novel, it's all very well surviving an interlocutory challenge, but you will have to prove your case at trial. And ultimately, it does seem to me that the merits of your case, and in particular the evidence said to support abuse, will be decisive. So I do think this first development is a potentially very interesting one for claimants. And I think in a nutshell, it gives a lot more flexibility to run different and new types of abuses and present certain challenges for defendants and to some extent for the court and the judges. Now, the second issue on the next slide I wanted to address is another surprising recent development. I mean, many of you in this meeting will remember that excessive price control relatively recently was considered effectively a dead duck. And we had a surprising revitalization in the Ascot case, Italy, and before the Commission, which is recently settled, phenatone, which Dame Kelyn mentioned, and a number of pending CMA cases, hydrocortisone and liothyronine, for example. And it was very surprising to many practitioners that this has been revitalized, because since the Commission's decision in the Ports case, it had been assumed that this was a very difficult abuse to prosecute, and to some extent, this has been revitalized. Now, the other development, which to me is even more surprising, is that there is some pretty old case law on non-price exploitative abuses. The Tetra Pak case, for example, and the BOT case, which are cases from the 70s, 80s, and 90s. And these seem to be cases that were had fallen into disuse. But particularly in the context of platform abuse allegations, there has been a revitalization of non-price exploitative abusing cases. There are two cases which I mentioned, Match and Epic Games, which are currently before the CMA. And that is essentially a commercial dispute between the platform operator Apple, in this case, and companies like Match and Epic Games who distribute their products on these platforms. And it's essentially a dispute over the commercial fees charged as a percentage for commission for distribution. And these allegations are being presented as forms of exploitative non-price unfair conditions. Many of you, of course, will also know the Facebook Germany case, which was an unusual case where a reduction in privacy protection was found to be a potential abuse on the basis that firms in that market compete over levels of data privacy. And to some extent, the recent Preventex case picks up on that theme. And Mr. Justice Roth, in that case of 95, he said that the recent German Facebook decision indicates the potential breadth of the provision in Section 18 and Section 18.2a and Article 102a on unfair conditions. Now, moving to the next slide, again, in terms of unpacking this for purposes of litigation, I mean, I do think this does present opportunities for claimants because, I mean, fundamentally, the conditions in the older case law like Tetra Pak, necessity, proportionality, I mean, they're pretty gelatinous and they're hardly consistent with legal certainty. So I think there are certainly opportunities for claimants in the case law on exploitative non-price conditions to come up with interesting theories. So that I think is a positive for claimants. And second, I think much more interestingly, that there is an open question, but it does seem to be the case that where one has demonstrated unfairness or exploitation within the meaning of Section 18, you do not then also need to show separately an adverse effect on competition. In other words, the effect on competition may well be the unfairness itself. And once that is shown, you don't need to show anything else. And I've set out on the slide a quotation again from Preventex, where Mr. Justice Roth seemed to think it was at least arguable that the authorities, both on price and non-price abuses, show that it is not necessary to show a distortion of competition to establish that form of exploitative abuse. So that is a second reason, maybe a very compelling one, why these may be attractive abuses for claimants to run, because unlike all of the exclusion cases, perhaps subject to the question of object, which David will deal with, one doesn't need separately to show an effect on competition. So that, I think, is to the good for claimants in litigation. Now, on the other hand, I mean, I do strongly detect that hard-nosed commercial court judges will not be really in the business of acting as public rate setters on price, and will not be in the business of rewriting contractual bargains in the form of unfair non-price conditions. And there is an older case law from the High Court, the Humber Oil case and the Inez Finals case, where, at least in the context of pricing abuses, the High Court seemed to take a pretty hard-nosed approach, or certainly imposed a more demanding standard on claimants. So there is an interesting question as to whether, in general, the High Court will be willing to run with some of these novel recent cases. Now, my own view is that it is certainly clear, as we've seen from cases like Facebook Germany, and somewhat less directly, or at least remains to be seen in the Match and Epic Games cases, that unfair price and non-price conditions, they're bound to play an important role in the context of the so-called platform cases. And they're also likely to continue to play a role in the context of novel issues such as a reduction in competition in respect of data privacy. So that seems to me an obvious area where the notion of exploitation will continue to develop. There is an interesting sub-theme here, which is, as we know in the UK and at the Commission level, there has been regulation, including the ex-ante regulation, proposed to varying degrees in respect of platforms. Now, that does raise an interesting question as to how this will feed into the question of ex post competition law and abuse. And one could see it pulling in different directions. On the one hand, you would expect that if the ex-ante regulation is addressing through specific conditions what is or is not a fair condition, then there would be less need for ex post competition law to step into the breach. But I suspect what one may see is as much things going the other direction, which is that perceived gaps in regulation may end up being plugged, or at least claimants will attempt to plug them through the use of ex post competition law. Because to some extent, in cases like Phenytoin, you already see ex post competition law being used to plug perceived gaps in regulation, or at least ways in which regulation can be arbitraged to exploit a gap. So I think there's a very interesting question about the intersection between ex-ante regulation and platforms and how that will impact on the treatment of ex post abuses in this area. Now, the final point I want to deal with before handing over to David is the question of discrimination on the next slide. And again, I've rather elliptically called this the snakes and ladders of discrimination. Now, what I mean by this, as many of you will know, I mean, in theory, of course, if you look at Section 18 in Article 102C, it seems that any difference leading to a competitive disadvantage in comparable transactions is potentially abusive, subject to the question of objective justification, at least in theory. Now, in practice, certainly until recently, the courts and the public authorities have been very sensitive to the scope for the use and abuse of non-discrimination clauses in abuse of dominance laws in a sparing manner. And there are very salutary lessons in the United States where the Robinson-Patman Act, which is the non-discrimination law in the United States, has in many cases had very anti-competitive outcomes and has often been used as a way to refuse to give a discount you were otherwise minded to give. And there are some indications in recent cases, such as post-Denmark, where the court has said, at least in the context of exclusion, well, the mere fact that the alleged abuse is discriminatory does not mean that it is abusive, it is exclusionary. One needs to show exclusion, and discrimination in this context is neither necessary nor sufficient. Now, there have been some recent developments in respect of discrimination that, in my view, are potentially very important, and they actually pull it in quite different directions. So the first case I'm talking about is the Meo case, which is a recent reference to the Court of Justice from Portugal on the question of discrimination specifically. Now, on the one hand, in terms of ensuring that discrimination cases are tractable and don't lead to commercial problems, the court does make the conditions for discrimination more demanding, because they do make clear for the first time, at least with proper clarity, is that the disfavored party needs to show that the compared parties compete with each other first, and second, that the disfavored party's total costs are materially affected by the alleged discrimination. And you see there the quotation from the Court of 26. The mere presence of an immediate disadvantage affecting operators who are charged more does not, however, mean that competition is distorted or is capable of being distorted. So that seems to be a positive development, at least if you're a defendant, because it does make the conditions in Section 18 and 102C that bit more demanding. Now, on the other hand, of course, once these conditions are shown, and they are demanding at a certain level, but obviously not impossible, it does seem that there is then an abuse, subject, of course, to the important question of objective justification. And that, in my view, is an interesting development, because one can see in commercial life the real problems of a very strict non-discrimination principle. And one would have expected, perhaps, the Court of Justice to make some judicial nod in the direction of discrimination needing to be curtailed, in the sense that it shouldn't be applied too expansively. The Advocate General certainly makes some noises in that direction, but the court doesn't really pick up on the point. So it does mean that when these modified conditions are satisfied, that perhaps paradoxically, the scope for discrimination being an abuse is today perhaps slightly greater than one had thought before the MEO judgment, because I did think, as I said, the court might say something about the potentially problematic issues that arise with a pretty strict non-discrimination principle. Now, just to wrap up on the last slide before I hand over to David, just to sort of try and unpack this a bit. So, in my view, it's very important to distinguish at least two different situations. The first category really is the MEO case. That's where you're dominant and you supply customers, but you are not competing downstream with the customers. So that is a purely secondary line injury case. Now, one can perfectly see in that context that if there's a difference in treatment, there's probably a good objective justification reason for that taking place. And all else equal, these cases are probably of less concern for that reason. Because if the dominant firm is not active downstream, then it has no particular interest in distorting competition downstream. And if there is a difference in treatment, there is likely to be a good reason for that taking place. Now, the second category, which I think is potentially more problematic, but really is a different category altogether, is where you've got vertical integration. And that's where the dominant firm supplies customers who it also competes with. So that's the primary line injury case. And that, of course, is a case like public parking. Now, just to focus before I wrap up on this second category, There is a lot of somewhat older case law saying that where there is actual discrimination by a dominant firm in favor of its own downstream operations, that is subject actually to a pretty strict set of principles. And I've put up there cases like GT Link, Irish Sugar, and a couple of recent commitment decisions. I mean, by and large, in my view, these cases are about newly liberalized markets where there's a former incumbent that continues to practice actual discrimination against new entrants, and one can see why that is interpreted pretty strictly. But there is a very interesting wrinkle on this in purple parking, because in purple parking, Mr. Justice Mann said, well, if this case was analysed on normal exclusion principles, purple parking would have lost because they would not have been able to satisfy the Bronner conditions, and he says that expressly in 143. However, purple parking did succeed in the claim purely on discrimination grounds. So what it shows in practice is that certainly in the context of vertical integration, the discrimination analysis for claimants may actually be more permissive or easier to satisfy than a straightforward exclusion case. Now, I think David may pick up on this in a bit more detail in the context of Royal Mail. Final point I want to make is that it is undoubtedly the case that in the context of platforms and the elliptical concept of self-preferencing, that the notion of discrimination in general by platforms in favor of their own activities will continue to grow like topsy. And I think, if nothing else, discrimination in that particular context will continue to play a very, very important role. So those are the 3 points I wanted to highlight by way of practical recent substantive developments. And I'll hand over to David. Thank you very much.
Thanks very much, Robert. So we'll now go to David. And just to remind you, there will be time for questions at the end. And if you have burning questions already, please do type them into the question box while David is speaking, and we'll pick up as soon as he's finished his presentation. Thank you, David.
Thank you, Kelyn. Thank you, Robert. So I've picked 3 issues, all of which have arisen over the last 21 years, this century, where we've moved from a position of consensus to a question of new concepts, new challenges to orthodoxy. If one went back to the turn of the century in 2000, one would have seen that there was an emerging consensus that the law and abuse of dominance needed to be less formalistic and more effects-based, that there needed to be less concern with particular competitors and more concern with those that could compete head-to-head as efficiently as a dominant firm. And of course, back in 2000, even Mystic Meg or anyone with a crystal ball couldn't predict that the UK would leave the European Union. And so I'm going to deal with those 3 issues, the question of an abuse by object, as to which we go to my next slide. Then I'm going to turn to the rise of protecting less efficient competitors, or the sort of the reappearance of those. And then finally, say some words on Brexit. So we can go to my next slide, please. Of course, for many competition lawyers, restrictions by object are a familiar and well-traversed part of any Article 101 case. If you look at the diet of decisions taken by the CMA and also by the European Commission, many of them are object cases. But neither Article 102 nor Chapter 2 has this object or effect distinction. The key, of course, is to look at what the courts in fact have done. And notwithstanding all the clarion calls for effects-based analysis in the early part of this century, it's pretty clear to me that there are certain types of conduct that are inherently harmful to competition, and as Robert said, have as their purpose the restriction of competition, and therefore are categorized as abuse. If you start with the sort of nutty professor example, that would be one where a dominant firm blew up a competitor's factory. Now, there's really obviously issues there of criminal damage and tort, but also actually a direct question as to eliminating a competitor's facilities in that direct and obvious way doesn't have any efficiency benefits, doesn't have any objective justification, and clearly therefore is an abuse. And Robert alluded to the fact that the law on predation, which goes back to the early 90s, has very strong presumptions that go against prices below a measure of cost. And again, that is reflecting that there's no real economic justification for sacrificing profit other than to destroy competition. What I think is quite interesting is that when you start to look you see more and more of these abuses by object. Robert started with the death of the pigeonhole. Maybe I can call mine the birth of abuse by object. It's not cradle to grave, but grave to cradle. And what one sees in particular with the Lithuanian Railways case decided by the General Court last year is something that I don't think even the most imaginative author of the Rome Treaty would have anticipated would fall within the prohibition. Lithuanian Railways is in some senses the poster child of the abuse of dominance cases. It's a state-owned company. It's a vertically integrated company. It has a strong incumbent position. It not only owns and runs the track, but it also owns and runs its own railway service. If you go to my next slide, please, I have a little diagram to sort of illustrate what happened. In essence, one customer that owned an oil refinery, in the bottom left hand of the picture here in Lithuania, had the temerity to switch from Lithuanian Railways to a rival operator to move the oil from Lithuania into various ports in Latvia. And Lithuanian Railways' response wasn't to improve its fares or improve its service, but was much more simple and straightforward. It just simply took up 19 kilometers of track, the little red dotted line in the bottom left-hand part of the picture, that connected Lithuania to Latvia. And instead, what that meant was that the customer had to use the blue dotted line, which was a much longer, more time-consuming, expensive service to get to the various ports in Latvia. Now, in most abuse of dominance cases, one of the things you want to ask your client, of course, is, well, why did you do this? And in this instance, there really only was one answer. The answer was to punish and discourage a customer from choosing to use a competitor. It's actually quite similar to some of the payments that Intel made in the Intel case, where it paid various customers so that they wouldn't market or use competitors' chips. And so the Commission in its decision simply says, well, whatever competition on the merits is, this is not it. And so if you rip up part of your railway track, then your object is to restrict competition, restrict and distort customer choice. And if anything's an abuse, then that is. But in some ways, consistent with the trend that Robert was identifying, Lithuanian Railways appealed and they said, well, wait a second, you've got to have a legal test. It can't be just, as David Edward, former judge of the General Court, once said, it can't be just the smell test. If it doesn't smell right, then it's an abuse. That can't be usable by anyone. And so they said, well, the test here ought to have been, was the dismantled track an essential facility? Was it indispensable within the meaning of the Bronner judgment that Robert referred to? And what we know from the General Court last year was that, well, actually, no, that isn't the test. Paragraph 98 is very clear that you don't need to shoehorn or pigeonhole yourself within that line of case law in order to show that there's an abuse. It is enough simply to say that the conduct had the purpose of restricting competition, that there's no objective justification, and that therefore it is an abuse. And what I find quite striking about that is that that does have implications for litigation. As Dame Kelyn referred at the outset, I'm involved in the Consumer Association's case against Qualcomm. And one of the things that's quite interesting about that standalone action is that the way in which it puts its case is, again, with beguiling simplicity. It just simply says Qualcomm's behavior in a variety of ways was not competition on the merits. It was effectively forcing smartphone manufacturers to have to pay higher royalties for various of its 4G patents. And of course, in that sense, it's quite a pro-claimant development. You don't have to prove effects, and it may be possible to use more expedited procedures. And of course, you can start to turn the screw on defendants insofar as you seek disclosure of various documents relating to dominant firms' strategy. But always with these things, be careful what you wish for, because in other cases where this argument has been run, like in StreetMap and Google, one of the arguments advanced by StreetMap was that Google also had a wicked intention and was seeking to squish the rival mapping provider. But when that came to trial and when Mr. Justice Roth made his findings, he actually found, by looking at the documents, that Google's intention was far from being in some way inimical to the competitive process. It was actually pro-competitive conduct, a finding that then actually influenced all of his subsequent findings, because he said that actually in that case, Google was acting on the merits. Before I move on, I should just flag one or two other things that caught my eye. Let me just flag two in particular in the Baltic Railway case. The first is that when it came to the fine, because clearly a serious abuse ought to be fined, the General Court, and it doesn't do this very often, but it found no fault with the Commission's calculation of the fine, but then, in using its unlimited jurisdiction, knocked off 8 million euros. Why? Just decided that it took a different view to the Commission. It's the first time I've really seen the General Court do that. Of course, the CAT sometimes takes a different view of gravity and of the impact of an infringement, but here the General Court was doing it of its own volition. The other thing that caught my eye was the remedy. I mean, that's obviously of practical importance to both sides. And the Commission in its decision simply ducked the issue and said, you need to bring to an end the infringement. But of course, there are different ways in which you could do that. One way, one obvious way, would have been to say, well, rebuild the track. Query, could the Commission have actually required Lithuanian Railways to do that? And the Commission's view appeared before the General Court to be that no, that's not within its remit. There was a judgment against Microsoft a few years ago that said that actually it's for the dominant firm to choose from various lawful possibilities how it brings to an end an abuse. Lo and behold, although the Commission never required it, Lithuanian Railways has now rebuilt the track. And so the customer's happy, the competitor's happy, but Lithuanian Railways is not happy and is appealing to the Court of Justice. If we move to the next slide, please. And I'm now going to turn to our second issue. And in some sense, this is kind of going all the way around back to the very beginning of jurisprudence on Article 102. If you look at some of the early cases in the 1970s, one of the striking themes was that the victims of the abuses found, taking commercial solvents, for example, was a small company, a family-owned company, and one that could never have been as efficient as the dominant firm, but that didn't matter because that wasn't relevant to the analysis. But one thing that's quite striking, particularly in cases like the ones that Robert mentioned, Post-Denmark 1, for example, is that the lodestar of those cases is that one should now focus on those that can basically give the dominant firm a run for its money. Can it compete as effectively on price, on quality, on innovation? And the court in Post-Denmark, and more recently in Intel, was crystal clear. Competition on the merits will lead to the demise of less efficient competitors. That's the rough and tumble of the Darwinian struggle of the market. But what I find interesting, if I can move to the next slide, please, is to test the limits of that general proposition. Because in competition law, you should never say never. And it does appear that there are certain situations where competition law does protect competitors that are less efficient than the dominant firm. And that point has been explored both in Luxembourg, in the Post-Denmark case, and here in the UK, in the Royal Mail case. And I don't think it's a coincidence that they both arise in the postal sector, because that is a sector that has state-owned or former state-owned monopolist. It is a sector characterized by substantial economies of scale and network effects. And the bottom line is that a new entrant doesn't have any hope of achieving equivalent efficiencies to the incumbent. And so, of course, if you apply the as efficient competitor test strictly, there'd be no way that an entrant could be as efficient and no way that there could be a competition problem. It would basically say that there's nothing to see here. And as Robert alluded to earlier, this was a key point in the Royal Mail case. And in a nutshell, if we move to the next slide, please, I have a little diagram to illustrate that. Royal Mail, as everyone knows, now a private company, but owns and runs 99% of the end-to-end delivery of letters and parcels in the UK. And so the bit in red is essentially the mainstay of delivering mail in the UK. But there were attempts to liberalise that sector, and that's essentially what the top bit is about. It's about new entrants coming in to sort various business letters, part of the bulk mail sector, and then either deliver it themselves or much more often use Royal Mail. And the crux of the case was that Royal Mail realised that this was on the cards and decided to change the prices it would charge competitors for using its delivery infrastructure, for using shorthand. And Ofcom looked at this and decided that actually, no, this was part of a deliberate strategy to discriminate against competitors and was an abuse. And the key point, one of the key points on appeal, was whether actually it was necessary for Ofcom to show that the victim was as efficient as Royal Mail, and that Ofcom had failed to apply the as efficient competitor test. Now, the judgment of the tribunal is long, weighty, and is perhaps better suited to sort of body lifting. But the key point that the tribunal makes is that the as efficient competitor test is not mandatory as a matter of law, and we knew that from Post-Denmark 2, isn't actually desirable as a matter of principle, and that's because the tribunal suggests any conduct that restrains rivals from competing on price should be an abuse, absent an objective justification. I think now there it's a bit more tricky because there's a tension between what the Luxembourg courts have said, competition on the merits can lead to the exclusion of less efficient competitors, and what the tribunal seems to be saying, paragraph 488, that actually sometimes that can cross the line and become an infringement of 102. But I think for my money, the key point is facts matter. The circumstances of this case and in Post-Denmark meant that it was never possible for any entrant, no matter how popular and good and superior they may be, that they could compete with Royal Mail. And I think if that in some ways also reflects something that Robert said, if there's the death of the pigeonhole, there's really the birth of a fact-sensitive assessment of abuse. One can see that not just in Royal Mail, but take in Street Map Google. Street Map failed to show that Google had abused its dominant position. It had a sound theory of harm, all about favoring essentially one of Google's own products using its search engine, but failed on the evidence. It didn't have any evidence to show that there was any harm to the process of competition. That same theory of harm underpins the European Commission's decision in relation to comparison shopping services. That's on appeal to the General Court. But it does seem to me that one has to sort of keep that in mind in order to sort of acknowledge the flexibility of Article 102. And I think in terms of litigation, it means that there is an increasing pool of claimants that may be able to bring these type of cases. And of course, it also simplifies from the court's perspective how these cases would need to be judged. Because if there's one thing about the as efficient competitor test, is that it's relatively easy to state, but actually much more difficult to apply. And you can see that from the Commission's analysis in Intel itself, the various assumptions that have to be made about the share that rivals would acquire, the time horizon, and various other aspects require assumptions and projections, which mean it's actually not an easy test to apply. We turn to the next slide, please. And this brings in a subject that is a polarizing subject, but now a reality. And what I would like to do is to address two issues. And we go to the next slide, please. The first is how the legal landscape has changed. And in short, it's changed in two major ways. The first is that from a litigation point of view, following on from European Commission infringement decisions is still valid so far as the decision was taken before Brexit occurred at 11 o'clock on the 31st of December last year. And subject to one important exception, it will no longer be true for Commission decisions in the future. The exception arises out of the Christmas deal that the government did with the EU, the withdrawal agreement, which allows the Commission to have continued competence in all those cases where it's initiated proceedings. I think for some time to come, therefore, when the Commission takes decisions in cases against Amazon, perhaps against Facebook, those decisions, insofar as proceedings have been initiated, will be binding on courts in the UK. But the other big change is one to how our rules will be interpreted and applied in this jurisdiction. Section 60 has gone. Like a phoenix from the flames, Section 60 big A has arrived. And it does two things. it, rather like Miss Havisham in Great Expectations, is obsessed with the past. So we're now bound to have consistency with EU case law and decisions insofar as they arose before Brexit took place. But as far as the future goes, that's up for grabs. There's nothing in the legislation that says the weight or even the relevance that a court authority has to have vis-a-vis future decisions. And of course, it's a separate point as to the weight and relevance that a court or even parties may pay to those future decisions. If you think about the rules are very similar in terms of their wording, in terms of their purpose, that actually businesses have every interest to try and have similar rules applied similarly to reduce the burden and uncertainty on them. And moreover, there is all the experience that would inform developments in Luxembourg. The final point I wanted to make on section 60, big A, is that although there is a duty to maintain consistency with pre-Brexit case law, there is one very important exception set out in subsection 7. And basically what it does is it allows the courts and authorities to depart from pre-Brexit case law when any number of specified situations arise. And that might be because competition analysis has evolved in thinking, or new forms of economic activity have arisen, or that there are basic differences between the UK and markets in the European Union. And of course, what that means, seems to me at least, is there is plenty of room for argument. And therefore, although there is in the statute a duty of qualified consistency, there's going to be a lot of time and litigation and argument to see whether or not there should be deviations or departures in due course. If I turn to my final slide, and that deals with some of the practical implications, I'm just going to deal with one, and that really is about the implications of Brexit can be overstated, and in particular overstated in terms of how the law is applied in practice. I predict there's more of an evolution rather than a revolution. If you look at the number of Chapter 2 cases that are brought, even in the course of this year, against Microsoft, against Qualcomm, against BT, I think one thing that's interesting is that it is already being embarked upon in private litigation, that the litigation here has more probing evidential standards, and the expectation of the courts in terms of what parties must do to prove their case is in many ways quite different from how that is approached in Brussels and in Luxembourg. You know, the role of live witnesses, for example, and the extent to which a court engages with experts is quite different from the procedure that one observes in the General Court. So although Brexit means that we're no longer bound by how the EU evolves, it seems to me that we have already a system that relies heavily and is influenced heavily by European case law. And so actually, the more interesting thing will be to see how similar cases, perhaps cases brought against Facebook and Google in due course, how they are decided and analysed in between London and Brussels. And that concludes my presentation.
Thank you very much, David, and thank you also, Robert. Just to remind everybody that there's some time for questions. So if you have any questions, please do send them through in the question box, and I can ask them of Robert and David. Just to get the ball rolling, can I pick up on, David, your comments right at the end there? And it seems to me that you think that there may well be considerable continued convergence of UK law and EU case law post-Brexit. Robert, can I ask you to comment on that, whether you agree with that? And then David, perhaps then you can come in and give a view on whether you think there are particular areas where UK law could, might even be likely to diverge from EU case law going forward. So Robert, first of all.
Okay. Yeah, I mean, I think I've got a more sort of mixed view than David. I mean, it does seem to me that in large part because of the procedures by which Chapter 2 is applied in this country, either in the context of B2B litigation or merits appeals to the CAT, that the UK to a good extent has tended to do its own thing when it comes to abuse. And in particular, as David said, I think the demands of live evidence and the stringency in general of the courts in terms of proving your case has probably led in general to a more rigorous application of abuse principles. And it is interesting if you look internationally. So cases like NAP, Genzyme, leading CAT judgments, I mean, they have become templates for similar analysis conducted by many other jurisdictions in South Africa and Hong Kong and so forth. And I mean, my view is that regulatory competition, if I can call it that, is inherently a good thing, because it will lead the competition for ideas and the testing of ideas in the real world will ultimately lead to better outcomes and to a better set of principles being established. So to some extent, I sort of welcome regulatory competition. I think it's a healthy thing. I think it did exist pre-Brexit. It will undoubtedly augment post-Brexit, and I think that's essentially all for the good.
David?
To give one specific example of where I think UK future practice may differ from EU practice is really in the realm of Robert's second issue, exploitative abuses. Because it seems to me that if you look at the Court of Appeal's judgment in Finatoim, and you see what is set out very clearly by Lord Justice Green at paragraph 97, and sort of the steps, albeit applying EU law, but doing so with a bit mindful of principles of domestic administrative law and what an authority is expected to do. I can see how that may influence and clearly should guide and influence future enforcement practice against excessive pricing. Whereas the European Commission isn't bound by and argued against some of those principles set out by the Court of Appeal. And when one looks at, for example, the commitment decision in Aspen, you can see that the Commission is not following the same logic and is not bound to either. And I can see how, in that respect, one might begin to observe some differences. A different example, if I may, if one goes back to the Court of Appeal's judgment in National Grid, well, Justice Richards was very clear that in Chapter 2 cases, you need to give some explicit consideration to the counterfactual. It's a matter of expert appreciation, but it has to be thought about. The thing that's always struck me when looking at a lot of abuse of dominance cases is that that's almost always assumed. It's not like in cartel cases where damages have to be compared to a counterfactual, or 101 effects cases where, again, the counterfactual is very explicit and very clear. In fact, in 102 cases, it's somewhat neglected, or it's sometimes even overlooked. And I wonder whether that's another example of where the UK particularly will need to think about what the but-for world would be in the absence of alleged abuse. You don't seem to see that much consideration of it in European Commission decisions.
Thank you very much. Now I've got a couple of questions from our audience. Let me start with a question from Nicholas Khan to you, David. Can you comment further on the CAT's interpretation of paragraph 136 of Intel in its Royal Mail judgment at paragraph 482? Do you consider that it's sufficient that market conditions are such that an AEC cannot emerge for it to be sufficient that the protection of Article 102 is not limited to an AEC in the sense used in the AEC test?
So I think that the tribunal was mindful that in the particular circumstances of Royal Mail, there was never going to be the possibility of a competitor as efficient as the incumbent. And that was particularly because of the features of that sector. I think the interesting thing about the Post-Denmark case is, written, by the way, by the same judge rapporteur, is that Post-Denmark 1 comes out with a very clear statement that one should focus on as efficient competitors, albeit within the context of essentially price discrimination that was said to have exclusionary effects in one and the same market. Whereas in Post-Denmark 2, the court was very clear that actually 102 has a broader remit, that its protective purpose can extend beyond simply as efficient competitors. And I think neither the Luxembourg courts nor the tribunal was trying to exhaustively state the circumstances in which less efficient competitors might be protected. And I think the thing that reinforces my view about that is that the European Commission itself, in paragraph 23 of its guidance on enforcement priorities, is also mindful that, yes, one looks perhaps in the first instance as efficient competitors. You've also got to think on a dynamic basis that perhaps someone that's not as efficient today might grow and become an efficient challenger in the future, a sort of not yet efficient, but soon to be as efficient competitor test. Now, that's not catchy to say, but it does seem to me that it might sometimes play a role in deciding cases.
Thank you very much. And I think we can just squeeze in one more question, and this is for Robert from Sahar Khan. On Facebook Germany, how are unfair privacy demands a competitive parameter? What was the court's reasoning in transposing privacy concerns into competition?
Okay. So as I indicated, I mean, this is pretty controversial stuff. But as I understand that the reasoning was as follows. So they said, well, platforms compete across a range of parameters. One, of course, is the size of the network and its usability and so on. But they also said that platforms compete in terms of differing levels of privacy. So having more privacy protection may well be a parameter of competition. Now, if you look at merger decisions in the context of LinkedIn and WhatsApp and so on, it is certainly now fairly orthodox to say that competition in respect of levels of data privacy protection is a thing. So, I mean, to that extent, it is difficult to say that they're completely off beam. Now, I think the more sort of precise criticism is that, I mean, ultimately data privacy is a value judgment imposed by society, balancing up the interests in dissemination of information versus privacy of individuals. And that is a piece of secondary legislation under EU law. And I think there are concerns in effectively using secondary legislation as a sort of template for primary legislation in the form of 102 or domestic legislation that means in terms of abuse. And what happened in Facebook Germany was interesting. I mean, effectively, the Bundeskartellamt obtained an opinion from the data privacy regulator as to whether the alleged reduction in privacy in that case was something which would have been problematic as a matter of data privacy law. But it is controversial because what you're effectively doing is cutting and pasting an opinion on data protection levels and grafting that onto the concept of abuse. Now, in terms of unfair conditions, I mean, I guess one could shoehorn this into, well, is the reduction in privacy necessary? And if it's necessary, is it proportionate? But ultimately, what one is doing is forming an evaluative judgment of data privacy protection levels, and that seems to me quite a difficult thing to do in the context of competition law. So I think these decisions, they will run and run, and they will have to be developed, but it is not without controversy.
Thank you very much. David, do you have any comment on that before we bring the session to a close, unless there are any other questions?
Just a brief comment, which is that it does seem to me that one often observes in Article 102 cases an intersection between competition law and another area of law. You can see that in AstraZeneca with patent law. You can see that in Facebook Germany with law on privacy and data protection. And what I find interesting is that in the Bundeskartellamt decision, they are using another law to inform how competition law should be applied. Whereas in some cases like AstraZeneca, actually competition law was being used to fill the gap in another area of law. So where there wasn't a remedy for lying to or misleading a patent office, nonetheless, competition law would step in. I suppose that's the interesting question about to what extent those should cross-fertilize one another, and to what extent that competition law, the concept of competition on the merits, is that really sufficient and sufficiently precise for case resolution? Because, I mean, I referred to the example of Baltic Rail, where it's pretty obvious. It becomes, to my mind, a lot more nebulous and much more difficult to use when you move away from that clear-cut case, and where one has to actually sort of grapple with how to distinguish what's legitimate behaviour from that we regarded as abusive.
Yeah, I mean, just to sort of wrap up on that, I mean, I do think fundamentally, where you're using non-competition legislation to inform the meaning of competition legislation, there is a fundamental problem, because the value judgments reflected in the non-competition legislation, they're not easily transposable to a competition sphere. That seems to me the conundrum which has never really been grappled with. I mean, it's all very well saying it's a matter of data privacy and all this would be problematic, but I don't see how it follows that there is then a reduction in competition. And that I think is the insight the question picks up on.
Thank you very much. Now I've got a one-word question for each of you just to finish. You've both referred to a number of recent, very interesting cases. Which one case should be top of our weekend reading list? David.
Slovak Telecom, because it just simply ties together a whole series of cases over the last 15, 20 years. It's quite a nice synthesis, and it's one of Robert's cases.
Thank you. And Robert, you can't say the same.
Well, that was a miscarriage of justice, so I won't. I think Royal Mail, I mean, I think it's a very long judgment that grapples with probably a dozen fairly fundamental issues under Chapter 2. I mean, it's on appeal as I understand it. I mean, whatever you think of the outcome of that case, I mean, the issues are teed up with great clarity and insightfulness. And I think it is worth the read and forming your own view.
Thank you very much to both of you, and thank you to everyone behind the scenes who's helped organise the first of this mini-series. And the next will be on, I hope I get this right, it'll be on the 22nd of April at 1 p.m. It will cover the very topical subjects of abuses and pharmaceuticals, recent and current issues in litigation. It will be chaired by Lord Anderson, and the panelists will be Jemima Stratford, David Scannell, and Tom Pascoe. So we hope to see many of you then. Thank you very much in the meantime to Robert and David.
Thank you. Bye.
Thank you.